Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Now this afternoon I'm looking at an excellent book from LEXISNEXIS. It's the most important book in its particular area of terms of practice, where the law is, how we do things, and it's the book which everybody will use in this particular specialist jurisdiction. It's the Court of Protection Practice. It's now effectively in an annual version for 2020, this one. It's this book here. It's been produced by a whole series of people who you will probably know. The consulting editor is Gordon Ashton. The senior contributing editor is Lord Justice Baker, Jonathan Baker, and there are a number of other people, including 10 contributors. I'll talk about them in a moment. The book itself, Elizabeth and I talked about the book, and Elizabeth did the main lead work on it, and I've been through it since then and put my own bits and pieces in, but it's because of my practice in this area. But I think it's excellent as a book, and she's given it the title, Where the Law Has Not Achieved a Settled State, is the quote. This is the definitive work of reference for all those involved in the work of the Court of Protection. It's now in a new edition for 2020. I'm not going to give it edition numbers because this is a book which is actually going to be an annual. What you do have, there's the book itself, you do have at the back a CD, which for those of you who have the computer with a CD in it, let me show you the book first of all. I mention the CD because a lot of books are now going over to the cloud and the web itself for updates, but we still have that particular CD as some assistance. There's the front of the book, and then there's the spine. There's nothing on the back. You can see some shaded bits for the various important chapters in the book. For instance, this bit is the civil procedure rules right in the middle of the book. Let me go to the end of the book. You'll see on the end there is in fact some information of some assistance. That is actually fixed costs in the Court of Protection. Again, very much the house style for LEXISNEXIS, to which I'm very thankful. What you have got then is a very detailed index at the back by paragraph numbering. So that is the style that they have adopted. And then you can see, just getting to the index itself, just to show you the beginning of the index. References are to paragraph numbers. It's important to know that because sometimes you can waste a bit of time wondering how to find things, but that does help. Then right at the back you have directories, the very last part. If I go to the front of the book, you've still got stuff on the inside cover. Those are calendars. They're actually very useful in practice because it's amazing how I might need that calendar when I'm looking at dates. You do have dividers of various sorts. This is these dividers, so you can actually find things quite quickly. So I'll just take that out and I'll show you again. You've got the front page there. There's a divider to actually find things. It does help, especially when you're in court, because I will be using post-it notes as well. There's the detail about the book. The pages are very thin. That's not criticism, it's just that that's the way it is. Can I just mention that the senior contributing editor is His Honour Judge Marc Marin, as well as Gordon Ashton and Lord Justice Baker. Then you've got a whole series of contributors mentioned there. Then after that you've got Sir James Munby. No, he's now retired, but he's still very powerful presence as the retiring president of the Court of Protection, obviously in the family division as well. I'm a great fan of his. I know a lot of people probably aren't, but I am. I think he did a wonderful job. And we've got, of course, Sir Marc Potter, going back a bit now, 2008, giving the forward to the first edition. And of course, Gordon Ashton's been involved really all the way through. But of course, things change. You've got an introduction. The introduction is quite important because Jonathan Baker's written it at the sort of tail end of 2019, before we had the COVID problems raising their head. And in fact, he makes a lot of very important points in the introduction. Do read that because it gives you an idea of what's up to date. Then you've got the content section, very standard. It's got 12 main parts to it. You've got all the usual stuff: statutes, SIs, PDs, codes, European information, tables of cases and so forth. You've got all of that at the beginning. Then you've got a narrative, the procedural guides, the legislation, forms, precedents, case summaries, then the Scottish legislation and guidelines and international conventions, and then fixed costs, as I say, right at the back, inside cover. List of abbreviations, very helpful, I found too. Then you can see it all running through statutes, then cases. In fact, that's statutory instruments, not cases. Cases are there. Then again, it's heavy, this book, so I'm going through quite quickly. I know some people like me to show the pages for a long time, but it's actually quite heavy to hold up for any length of time. After the cases, you then, as you can see, the pages are really very thin, but you then get into the various parts. So part one is the narrative, and that sets the scene, talking about preliminaries and overview and where we are today. Now again, I say this with a lot of books, we really do need to start looking at where we are with all these practice books for the 21st century, because things are changing dramatically with the way that the hearings take place, the use of IT and everything else. And we do need actually some new legislation. And once we've got the two problem areas sorted with this current Parliament, that is to say COVID and Brexit, I'm hoping that we're going to have some sort of government of vision that will start bringing some of these reviews of the law into being, and Parliament should be doing what it's been elected to do, which is to get on and start looking at the new legislation we need for the future. And I say that on behalf of a lot of people who I think will probably agree with me that we do actually need some changes. But you can see all the way through in the contents section a lot of detail, and then we get into the structure of the book itself. You've got, of course, here you can see the paragraph numbering down the sides there. You can see the footnoting, which is not right at the bottom, it's sometimes in the middle, depending on which paragraph you're dealing with. And you do get some commentary and some, I think, quite useful assistance, depending on what you're actually looking for. All of this is, at the moment, is about the narrative at the beginning. You've got a legal context section about how the legislation has developed, and it runs all the way through along those lines. As I say, the page runs to 2,500 pages at least. It's a very heavy book. It's a delight to review it again, because I haven't done that much work recently in court of protection proceedings, but it is a special jurisdiction, but it's a very important one. So let me tell you about what we think of the book. For those practitioners who work in or appear before the Court of Protection, this indeed is the definitive work of reference, having established itself since the first edition appeared in 2009. And James Munby remarked during that period of time that he's been involved that it's become an essential publication for every judge and practitioner in the Court of Protection. And he's absolutely right, it is. And in fact, it's the definitive one. And I think LEXISNEXIS are to be congratulated for overseeing the publication of this work, which is a great boon to everybody, the practitioners, the judiciary, the decision makers, the people involved at all levels. So thank you to them. And it's obviously this new edition is new from LEXISNEXIS. It's the latest one for 2020, and I think it's right to say it's a distinguished volume which covers virtually every aspect of what is a difficult and ever-expanding area of law, which of course offers up even more challenges during this fraught era that we're in, dominated by the scourge of COVID-19, which is not subsiding at the moment. I'm recording this in the autumn of 2020. I'm sure that these problems we have are going to continue for some considerable time. So I think it's certainly of interest that the book was published less than a couple of months before we knew the full horror of this virus and the true menace that it has wreaked on the planet. Bearing in mind that the consequences of COVID can only complicate realities in this area, which is both a complex and a sensitive area of law, the new edition can be regarded, I think, as a helpful guide to the complexities of recent legislation and also anticipatory glimpses into the challenges of the future, which I have already alluded to, with the need eventually for some changes to take place. Now, for example, the introduction by the contributing editor, Lord Justice Baker, Jonathan Baker, he wrote it in November, the 19th of November 2019. Rather prophetically, you might say, he expresses the hope that the next year will see concerted moves towards a greater use of digitisation. The HMCTS reform programme across all jurisdictions envisages a much wider use of digitised processes. Little could he, or anybody else for that matter, have foreseen that the use of digitised processes has not only achieved wider use, it's become the norm, accelerated by, of course, the threat of COVID. Now, it's not easy. I've been very fortunate to have done a few reasonable number of telephone hearings and applications prior to the COVID problem. But now I'm doing cloud video platform hearings, trials by CVP and Zoom and so forth. And we, of course, do a lot of telephone hearings to boot. It means you need 2 computers, 2 mobile phones at least, and you've got to think in a rather different way because of the way that you ask questions and the way you, obviously you don't want to speak over people, but there's always going to be that difficulty, especially in the non-visual environment. So therefore things have changed. Because, as I say, little could have been foreseen about this until we knew the full horror in February of 2020. And in a matter that no one could have predicted, the same threat has brought about the anticipated change that, in the words of Baker, most, if not all, case administration will be digitised by the end of 2020. I think we've got to that point, forced on us. And I'm not going to make too much of a comment, but I do have one criticism, and that is a lot of this could have been avoided if there had not been this stubborn reluctance by civil servants to prevent us introducing this way of doing things much earlier and in a slower process so that we got used to it. We've had to do it much more quickly. It's not about blame, but frankly they should think and reflect on the blocking when we've been trying for many years now to bring this in, the blocking mechanisms that were introduced for a lot of reasons. We are now where we are because as this review is written in the autumn of 2020, the predictive comments have now manifested themselves in a new and startling reality, which means that those who practice in the Court of Protection will appreciate this book more than ever for its intellectual rigour, its compassionate ethos, and the thoroughness and clarity with which it consistently deals with a difficult and sensitive subject. It's in the house style of LEXISNEXIS and of all the main practice books, so it's not too difficult once you get used to it to know how to find things. And of course this particular volume contains a wealth of resources for further inquiry and for further research and for time-starved practitioners like myself, and it's reassuringly easy, I think, to navigate. So all in all, this and the plethora of the new case law we have, which is presented in this new edition, make it an indispensable purchase, I think, for practitioners and judges alike in this specialist field. I'm very grateful to have this book. It did come out in the spring of 2020, but I'm actually recording this much later in the year. The reason for that is it's taken me a while to get things organised because, like everybody else, I've had the lockdown and other matters to deal with. But we are where we are at the moment. Let me just open the book. This is looking at the practice directions. You can see here, as I say, it is specialist. You can see how it's all structured, and you can run through with that. This sets out how hearings take place. You've then got other various practice directions that come into it. So you've got basically a one-stop shop for everything that you're looking for. Just looking again, this is another practice direction there. You see it's the shaded area in there which shows you where they are. If you go from that, you then go on to this is the Court of Protection practice itself with the children and protected parties practice direction. Then you've got a whole series of other, this is the public guardian practice notes, for instance, there. Again, going on from that, mental capacity legislation, the Act itself and so on. Again, you've got a little blocked area. Now that does happen occasionally where you've got a scenario setting out a particular problem which may be directly relevant. Now, I haven't actually used that part of it, but I think that's a very important development because it tries to bring, in what is a really difficult book to some people, it tries to bring some sense of the problems that we might be having with that particular scenario. There are some other scenarios as you go through the book. All in all, I thought that was a useful point for the book. There it is. A very big thank you to everybody. A lot of people are involved in these books. The publication, the contributions, everything else. But a very big thank you to everybody. I think this is an excellent book for the 2020s. Thank you. Bye-bye.